welcome to FFRF's Ask an Atheist program. I'm Annie Laurie Gaylor, co-president of the Freedom From Religion Foundation. Our timely topic today are the abortion ban cases moving at lightning speed to the U.S. Supreme Court. I have two experts with me to talk about that. FFRF attorney Liz Cavell, who wrote FFRF's Friend of the Court brief in the Mississippi ban case being heard by the U.S. Supreme Court December 1st. Thank you for joining us on Ask an Atheist.
Hi, happy to be here. And joining us both remotely is Barbara Alvarez. She is FFRF's Ann Nicole Gaylor Reproductive Rights Intern. Barbara monitors legislation and other government action that affects reproductive rights. She writes blogs and editorials for the Freedom From Religion Foundation, documenting the religious nature of the threats to abortion rights. And she's been busy lately. So welcome back to Ask an Atheist, Barbara.
Thank you so much for having me, Annie, Laurie, and Liz. It's wonderful to be back on the show.
Yeah, I wish we didn't have so much to talk about, though.
I know. But as always, you can join in our conversation by making comments. You can ask questions below in the Facebook comments, or you can email askanatheist.org at FFRF. No, askanatheist@ffrf.org. Sorry.
So, Liz, there are two cases concerning abortion bans that are before the Supreme Court that we want to discuss. And first, let's talk about what happened Monday morning, November 1st. What was the case before the court?
That's right. So we've talked about this law on past shows, but the Supreme Court heard oral arguments on Monday in two cases, both challenging SB 8. And if you remember, SB 8 is the Texas law that effectively bans all abortions in the state of Texas. It makes abortions illegal after 6 weeks of pregnancy. And for all you non-menstruating legislators, that is before most people know they are pregnant. That is 2 weeks after a missed period.
Yeah, good point.
And the law, the 6-week abortion ban is clearly unconstitutional. So this law was crafted intentionally to evade federal court review by making it enforceable not by government officials, but private citizens who can sue any person who performs, procures, aids, or abets an abortion. And it incentivizes those lawsuits by guaranteeing $10,000, basically a bounty, to citizens just for bringing suit.
And yeah, definitely. And also, it's important to note that SB 8 was crafted with a lot of help from Texas Right to Life, which is a Christian anti-abortion group that describes itself as a group that protects the God-given right to life. And so this law, it's very cruel, but as Liz is saying, it's crafted purposely to avoid judicial review.
So we want to talk about what happened at the Supreme Court Monday, but before we do that, Barbara, what's been the impact of this law?
The impact of this law has been overwhelming. Because abortion is effectively unavailable in Texas, only one abortion provider has provided an abortion to somebody after 6 weeks, and his name is Alan Braid, Dr. Alan Braid. He's been sued, but because the majority of women don't know that they are pregnant, they are traveling across state lines to the nearest clinics, and some of them are driving an average of 700 miles to the nearest clinic in Oklahoma, where abortion providers there are completely inundated. Oklahoma only has 3 abortion clinics, and abortion clinic operators are saying that they are having to extend hours. They have to hire more staff, and for the first time ever, they have to put a cap on patients they accept every day. And it's important to note that this abortion ban is particularly exacerbating inequalities for Black, Indigenous, people of color, rural and low-income people, and members of the LGBTQ community.
Well, of course, it just created chaos, and it's catastrophic, as Sonia Sotomayor on the Supreme Court actually put it. So, Liz, let's go back to the Supreme Court. You watched the arguments 3 days ago in this case. It wasn't about the merits of this case, correct? What were the arguments about?
No, so of course it's had the intended effect of abortions are effectively not happening in Texas, but no one was talking about that at the U.S. Supreme Court. The issues before the court on Monday were threshold issues, procedural. Basically, under these laws that were crafted in such a complicated way, can the people bringing the lawsuits challenging the law even get into court to challenge the constitutionality of the law? So there are two lawsuits, like I said. One is being brought by abortion providers in the traditional sense, but of course, because the attorneys general are not the normal enforcement government officials of this law, they've sued state court judges and state court clerks in order to try and get the courts to enjoin those state actors from docketing these private citizens.
So, in other words, if somebody wants to sue over this law, they are supposed to go into the clerks and file their lawsuit?
Yeah, so to enforce this ban, regular people, and usually it's Christian right-to-life groups organizing these lawsuits, they're supposed to go into court and just sue an individual person. It could be a doctor or a friend or an abortion fund provider or an Uber driver, as many people have said, anyone that aids in an abortion taking place in Texas. They go into state court and they just file a lawsuit against that person. And it's in state court. And so for lack of anyone else to sue, the abortion providers are trying to sue clerks and state court judges.
So the Supreme Court was going to weigh in on that potentially.
Right. Can anyone sue state court clerks and judges? And then the other case is also novel. It's the United States, the Biden DOJ, suing the state of Texas to basically defend the supremacy of federal constitutional rights because no one else has been able to get relief. That's not something that has happened.
And may I stop you there?
Mm-hmm.
It needs to be pointed out vigorously that the Attorney General is Merrick Garland. If things had happened the way they should have, Merrick Garland would be seated on the Supreme Court instead of Gorsuch, is it? Because his seat was stolen by Mitch McConnell when Obama tried to nominate him, and Mitch McConnell refused that. And we wouldn't be in this pickle.
Right.
Right so now, I just want to point that out.
It is important to note, but what is, I think, a really strong statement against what the state of Texas is trying to do is that Merrick Garland's DOJ is trying to sue the state in order to defend the constitutional rights of
federal rights.
Right, of Texas women, because unlike everyone else in the nation right now, they do not have access to constitutionally protected care.
So the Supreme Court on Monday was also hearing whether DOJ had the right to continue the lawsuit.
Exactly. So we're not even at the point where anyone's discussing the impacts of these laws and the merits of this clearly unconstitutional ban. They're discussing whether or not these lawsuits even have the ability to go forward just procedurally because they raise these novel issues.
And I think you've got some audio clips that you thought were kind of enlightening about that.
That's right. Those? So one of the clips is from the United States versus Texas case, and these arguments took place back to back with some of the same players, but of course Texas defending the law in both cases. So they overlapped a lot, but the clip I want to share is one from Justice Kagan, where she was really dismissive of the idea that, which is what Texas was arguing, that the court really, federal courts are just powerless here. There's nobody that can sue, and there's nobody that can challenge the law.
And no court that can review it.
Exactly. And what you'll hear her referencing, a court decision in this case, which featured heavily in the arguments, is called Ex parte Young. And it was basically a more than 100-year-old case where federal courts set out the way in which people can challenge unconstitutional state conduct. And it means, or it held that citizens can sue government officials who are charged with enforcing federal laws. And that is the way that we kind of access and challenge violations of those rights in federal courts.
So let's listen to that.
Let's hear Justice Kagan talking to the Texas Solicitor General.
I think what Justice Breyer is suggesting is that the entire point of this law, its purpose and its effect, is to find the chink in the armor of Ex parte Young. That Ex parte Young set out a basic principle of how our government is supposed to work and how people can seek review of unconstitutional state laws. And the fact that after, these many years, some geniuses came up with a way to evade the commands of that decision, as well as the command that the even broader principle that states are not to nullify federal constitutional rights. And to say, we've never seen this before, so we can't do anything about it. I guess I just don't understand the argument.
Right. So
she's basically, what this is really an attack on the Supreme Court. It's an attack on the precedent of the Supreme Court in Roe versus Wade, an attack on their ability to review law.
Exactly. And so I picked that clip because I love her deadpan snark, and the geniuses that came up with this are the Texas legislature and the Right to Life.
That Barbara mentioned.
Lobbyists. But what she's getting at upset a lot of judges, and not just the traditional liberal, shrinking block of liberal justices, but they were really impatient with the idea that they're powerless to do anything about this because Texas has figured out how to write a law that violates constitutional rights but is not subject to federal court review.
And so do you have a couple more clips?
Yeah, I do. So in addition to I mentioned not just the liberal justices, and specifically it was noted that Justice Barrett and Justice Kavanaugh expressed some skepticism about the law being this untouchable, unreviewable entity. But another thing that was raised that gets a little closer to the danger of a law like this being allowed to just stand without review is that it can be easily replicated. And even some conservative justices were expressing concern about how this law could be replicated in any state that disapproved of any constitutional right. And so the clip that I picked here is of Justice Sotomayor kind of giving some examples of that and pushing back on Texas. Again, the Solicitor General's answer was that, Congress could come in and create causes of action, and that's really the only answer. And so she's giving some examples of the potential ramifications of laws like this being replicated.
Can I give you examples where Congress has it? A state dissatisfied with Heller says, anyone who possesses a firearm anywhere is subject to litigation by any private citizen anywhere in the country and gets $1 million bounty. No stare decisis, no nothing. How about in Obergefell imposes SBA-style liability on anyone who officiates, aids, or abets a same-sex wedding? How about dissatisfied with Lawrence versus Texas, subjects a private consensual sexual conduct of which it disapproved to the exact same law as SBA 8? How about Griswold? The use and sale of contraception is subject to SBA-style liability. So this is not limited to abortion. That's the point that's been raised. It's limited to any law that a state thinks it's dissatisfied with.
Right. And so that's the obvious point, but of course it was worth thinking through some of these examples. And I was, shivered at the thought of the Griswold example, because of course that's where this is going.
Yeah.
More and more.
But also appealing to the religious right in a sense, or right-wingers by pointing out, hey, somebody who's against you owning a gun we could pass a law like this, and they could get $1 million bounty. I think that was the example she gave later on. $1 million bounty to turn you in for owning a gun. I mean,
and because it's enforced by private citizens, just like that, federal courts can't do anything to protect your constitutional rights. That example, of course, resonated with Justice Kavanaugh, who also picked up on a strange bedfellow, which was the Firearms Policy Council, or something, a gun advocates' rights group that filed an amicus brief here in support of the abortion providers, because they don't want to see laws like this replicated in liberal states.
Do we have another clip of him then, or what are we listening to?
Not
next?
of him. So we have one more clip, and we can play it now. It was just a very powerful statement by the United States. So representing the DOJ was the newly confirmed Solicitor General. Her name's Elizabeth Prelogar, and she, this was her first argument before the Supreme Court. She argued really forcefully against what Texas is doing to take away its citizens' federal constitutional rights. And this was her closing argument to the court, and we can play that.
Texas's position is that no one can sue, not the women whose rights are most directly affected, not the providers who have been chilled in being able to provide those women with care, and not the United States in this suit. They say that federal courts just have no authority under existing law to provide any mechanism to redress that harm. And if that is true, if a state can just take this simple mechanism of taking its enforcement authority and giving it to the general public, backed up with a bounty of $10,000 or $1 million, if they can do that, then no constitutional right is safe. No constitutional decision from this court is safe. That would be an intolerable state of affairs, and it cannot be the law. Our constitutional guarantees cannot be that fragile, and the supremacy of federal law cannot be that easily subject to manipulation. So we would ask this court to hold that the United States can proceed with this action and affirm the preliminary injunction entered by the district court and immediately vacate the stay that the Fifth Circuit entered in this case so that Texas cannot continue to deny women in its borders a right protected by this court's precedents one day longer.
Very powerful.
Very powerful, and those were the last words that the court heard on the matter that day. So it was a hopeful end, and it did seem to be resonating with the majority of the justices that the unreviewable nature of this law is just not tolerable.
Yeah. Anything you want to add, Barbara, about Monday's hearing?
Well, thank you so much for that really important discussion about it. I think it's clear that we can't rely on the courts alone to protect abortion access, and that we need Congress to step in and pass federal legislation like the Women's Health Protection Act, which would reverse this type of law and other type of medically unsound abortion restrictions. And I also think that it's important we highlight the important work that abortion funds and on-the-ground organizations continue to do in Texas to ensure that abortions can be as available as possible to the communities that need them. You know, every person should be able to make their own decisions about their health and their bodies. And so this is a really scary moment in our time, and we need to pass legislation.
And the Women's Health Protection Act passed the House. It's just sitting there in the Senate. So contact your senators. Now, we want to turn to Barbara for an update on this bad record-setting year for anti-abortion laws. But first, I want to talk about the other case, the upcoming case where the merits of the case are being heard by the U.S. Supreme Court, a case accepted long ago this year, the Dobbs case out of Mississippi. And Barbara, briefly, what is the law in Mississippi that the court is going to be hearing that challenge of?
Sure. So the Supreme Court will hear the oral arguments on December 1st for Mississippi Bill 1510. This bans abortions after 15 weeks of gestation, which is completely antithetical to the foundation of Roe v. Wade. And this is an important case because it could fundamentally overturn Roe v. Wade, because there is a long-standing precedent about viability to 24 to 26 weeks. Obviously, 15 weeks of gestation is far beneath that.
So Liz, you authored the amicus brief that I'm very proud that the Freedom from Religion Foundation did get before the court, and with some help from Barbara. We're looking at that on the screen. Barbara, you helped contribute to that. But Liz, first, what was FFRF's main contention in our front of the court brief?
Right. So we, FFRF, our interest in the case comes from a few things, but not least of which is our position that the obvious one, that religious ideology is what drives the anti-choice movement in the United States. It's the primary threat to reproductive freedom in this country and always has been the main organized threat to reproductive freedom. So that's our main interest. FFRF also has a lot of reproductive rights advocacy in its DNA, so we consider that really important to our foundation.
Yes, and I can say as a co-founder with my mother, Ann Gaylor, it was her early work for abortion rights, to decriminalize abortion rights, that opened our eyes to the absolute necessity of keeping religious dogma out of our laws. And in fact, this has been a very pivotal issue for the Freedom from Religion Foundation. Our 35,000 plus members recognize this. The survey we did last year showed 98.8% support Roe versus Wade. And that's, even though a majority of Americans support, that's much higher than the typical.
Right. Basically, all of our membership consider this a vital secular issue. And so for all those reasons, we have strong interest in all of these cases and just the fight for reproductive rights in general. So the brief argues, from our perspective, kind of the important point that we hate to see get lost in this argument all the time, which is that religion has always been at the heart of anti-abortion legislation. And Mississippi HB 1510 is no exception. It is motivated by religious ideology. There are many documented examples of not just offhand remarks, but comments in the legislative history of the bill. So things that are happening in the floor debate on this bill illustrate openly the legislators' religious motivations. And Barbara helped me with a lot of that factual research.
Yeah, so Barbara, there's, what do you say about that? Some of the quotes that legislators in Mississippi made at the time that they passed this law?
Well, in support of this anti-abortion law, Mississippi legislators said things like, "I believe that life is precious and children are a gift from God. And I'm not God, but I serve a God who says life is in the blood and this bill will protect those lives." Those statements are obviously rooted in religion. They aren't backed by science or medicine, and we live in a secular country, so we shouldn't be allowing Mississippi or any state legislators or any legislators at all to be passing legislation based on their religious viewpoints.
And those examples that Barbara's pointing out, like I said, it bears repeating. These are not things we've dug up in, people's, past, private comments. This is floor debate on the bill. These are things being said on the floor as we debate these bills. But as our brief points out, the justices on the Supreme Court, and therefore all the federal courts, have been traditionally very reluctant to consider the Establishment Clause arguments that could easily invalidate these laws because they lack a secular purpose. Barbara was talking about viability being the legacy of Roe and its progeny of cases. Well, viability is at least a science-based, evidence-based line at which the court can reasonably evaluate, okay, the state might have an interest that could override the pregnant person's interest. If we're talking about a viable fetus, a fetus that could survive outside the womb, before that point, the interests weigh completely in favor of the pregnant person's autonomy and their ability to make decisions with their physician about their pregnancy. And so that's a very clear line, despite what abortion opponents will have you believe. It's not really a muddled area of law. It's a pretty bright line. Abortion bans before 24 weeks. Bans. Now, states are allowed to regulate abortion to high heaven, and they do that with, parental consent laws and all these trap laws that have been litigated up and down and created other nooks and crannies of case law. So states are free to regulate the practice, but they're not free to ban abortions before viability. And that's what a 15-week abortion ban is. It's just a straight ban on abortions after 15 weeks.
For really religious reasons.
Right. There are some purported reasons. The anti-abortion movement has tried to develop these pseudoscientific bases that can push back viability. Fetal pain is a big one that is, written into the bill of the law. But even the language of the law
doesn't have science behind it.
Exactly. It's not science-based. It's
pseudoscience, or it's just an assertion.
Right. It's sort of law office science. It's science developed for the purpose of litigation. And then it's not evidence-based.
Our brief also points out that 16 of the friend of the court briefs in favor of the ban are by
religious groups, churches, ministries, or religiously affiliated or just religiously backed organizations like Right to Life that openly and explicitly have a religious mission behind their anti-abortion work.
So that kind of makes our argument for us.
Right. And of course, way back in the day, Justice, I think it was Breyer, or no, Justice...
I know who you mean.
In our brief.
Was it
Oh
Brennan?
my God, Stevens.
That's right.
Pointed this out decades ago, which is, you can see by the amicus participation in these cases that this is a religiously divisive issue, and that is where the arguments lie before viability. It's all about a belief that there's some sort of life, or ensoulment is kind of where it comes from.
The idea of ensoulment, yeah, because it's a life.
That's where
it's not a human being. I think is the issue.
Bans and things come from, and that's even in the language of the Mississippi law. I mean, they try to put it in secular language, but of course there's definitions in every law, and they define fetus or life or something as starting at a certain point. It's not science-based. It's based on theology.
It's based on which is not something that you can prove. And
right. So our brief is meant to point out that coming up, because the court is going to toss out Roe, the viability line, and say something like, that's nowhere in the Constitution, so we'll just do these on a case-by-case basis, or something like that. And we argued, what are you going to replace this with? Because viability is a workable, evidence-based tool for analysis, and everything else invites religious debate. And it always has been the problem with this debate.
And of course, also, it's the Catholic, and it's the evangelical, and it's the Mormon, but it's not all religions that believe this. So it's not like there's any kind of unity there with religion. It's just very divisive. Now,
right.
Barbara, do you have anything to add before we talk about the general state, which isn't good, of abortion rights? Since we last had you on Ask an Atheist, it was in July. Anything else you want to add about Dobbs?
Well, those are all some really important points, and I just think that it's especially important to note that the United Nations considers abortion a human right, and that denying access is discrimination and can constitute gender-based violence, torture, or cruel, inhumane, and degrading treatment. So this is a really important issue for human rights. Abortion is a human right.
So a lot has happened since you were last on Ask an Atheist. As I said, in July, we had then you, Liz, we had Jeff Stone, the law professor at the University of Chicago, talking about abortion rights before the Texas ban was even in place. You were talking about it then. But so it's not just Texas and Mississippi laws that we're contending with. What's going on in other states?
Well, this has been a record-setting year for abortion restrictions. There have been 106 abortion restrictions in just this year alone. That was in September, so that number might actually be higher. And for context, the previous record of anti-abortion laws was in 2011 with 89 restrictions. In total, since 1973, when Roe v. Wade was passed, we have had more than 1,330 restrictions enacted. These mean that 45 states have allow healthcare providers to refuse to participate in an abortion procedure based on religious grounds. We have 18 states that have mandated counseling that have misinformation, like the purported false link between abortion and breast cancer, fetal pain. So all those pseudoscientific things that Liz was talking about. We have 25 states that require a person to wait for their abortion anywhere between 24 and 72 hours after receiving counseling. And we also have 16 states that refuse, only 16 states that help out low-income women in obtaining an abortion. And I think it's also
and to
important
pay for an abortion, correct?
Yes.
Because of the
pay for
Hyde
an
Amendment,
abortion.
which isn't in the budget, but unfortunately it's sitting there also waiting for the Senate to approve it.
Yes. And it's also really important that all of these restrictions that we have seen this year, this record-setting year, and the 1,300 plus since 1973, this has resulted in crisis pregnancy centers outnumbering abortion clinics 3-1 in the United States.
Wow.
In some states, there are as many as 11-1 crisis pregnancy centers. And for those that don't know what a crisis pregnancy center is, it is a mostly evangelical, anti-abortion organization that masquerades as a medical clinic, and they target low-income people by promising them free medical care, but they often don't have a single medical care provider on staff, and they give misinformation about abortions.
And some of them are getting public funding.
Actually, yes. 27 states have crisis pregnancy centers operating with state funding, and that's important because that is taking away money from not only real science-based reproductive clinics, but these crisis pregnancy centers are subject to little or no legislative oversight.
So we're really in a crisis in our country with reproductive rights.
And Barbara, I hate to say this, but it's not just at the state level, right? Can you talk about municipal laws and bans that have been also coming down the pike?
Definitely. The state level, that gets a lot of attention, but there are a lot of local abortion bans that are happening. And this is where municipalities and cities are banning abortion within their district. So, for example, Texas has 37 cities that ban abortion.
Wow.
That means that abortion clinics can't operate in 37 cities. The most recent one, I believe, was in Lubbock, Texas, where there is an abortion clinic. And before this Texas abortion ban went down, this local abortion ban was running the abortion clinic out of town and forcing Lubbock pregnant people to travel about 5 hours to the next available clinic. Nebraska and Oklahoma each have 2 cities with anti-abortion ordinances. So it's not just on the state level, it's happening locally too.
So just to emphasize again, these bans are not backed by science. These are religious motivations. And
absolutely. And it's also important, thank you for bringing that up, Annie Laurie, because so many of these local bans are actually mobilized by local churches.
So do we have any good news?
You know what? We do have a little bit of good news to share. First of all, we're very happy that the Biden administration has reversed the Title X abortion ban on reproductive health centers that provide or refer people for abortions. So the Trump administration had made a domestic gag rule, which basically said that if you provide or refer people for an abortion, you can't receive Title X funding. The Biden administration has reversed that, which we are really excited about. We were supportive of that. And then most recently, Illinois just gave final approval to revoke a law that requires parents or guardians to be notified when their underage child seeks an abortion. This repeal is now headed to the governor's desk, where he is expected to approve it. And this is a really important move for reproductive rights in Illinois, but it also sets an example of what other states should be doing, because parental notification is a barrier to abortion access in many states. The ACLU has advocated for repealing laws that restrict teenagers' access to abortion. And research has found that 90% of minors under the age of 15 typically involve a parent or a trusted adult in their decision. But if they don't, the minority of teenagers that don't, they're doing it for justifiable reasons, because they're afraid of abuse, of retaliation, of being kicked out. And you can imagine that if a teen has extremely anti-abortion religious parents, that this could put them in a very negative situation, a very possibly dangerous situation. So it's important to repeal these parental notification laws. Illinois is setting the stage for it. And beyond the ACLU, major medical organizations also agree that parental involvement laws related to abortion risk the health and safety of teens. And those groups include the American Medical Association, the American Academy of Pediatrics, the American College of Obstetricians and Gynecologists, and so forth. So that's a really good piece of news that I hope other states follow suit on.
So while we await the various Supreme Court actions or decisions, what can we do now again, Barbara? What can viewers who are concerned about this do?
Well, as we were talking about earlier, I think it's pretty clear that we can't depend on the states completely, on the courts completely to protect abortion rights. That means we need some federal legislation, and the Women's Health Protection Act is an important step to do that. It safeguards abortion rights by nullifying state abortion bans, and beyond that, it also guarantees the right for patients to receive abortion care and for healthcare professionals to provide abortions. So this means that it protects against these medically unnecessary restrictions that we are seeing that create these burdensome barriers to abortion access. The Freedom from Religion, we submitted formal testimony in June in support of the Women's Health Protection Act, and the act did pass the House. It's now in the Senate, where there is a lot of resistance. So this means that we need those secular voices to be heard, and we need to call on our senators to pass this very important piece of legislation. So that's specifically for the Women's Health Protection Act.
And Barbara, you recently wrote a very comprehensive guide for FFRF members and other freethinkers about how you can get involved and how you can help fight to retain abortion rights. And it's on our blog site, FFRF. It's Free Thought Now, our blog site. And so there's a lot you can do. And if you are a member, you are getting our action alerts. You can also sign up for our Phone to Action so that you can be letting your members of Congress or state representatives know that you want to support abortion rights. And Liz, do we have anything else to add? Or we may have some questions.
Yeah, we'll take questions in a second. I'll just say one thing from the oral arguments on Monday against the Texas abortion ban. As the Solicitor General for Texas was getting pushed pretty hard on, how are people supposed to challenge these unconstitutional laws? And his answer was basically go ask Congress for help and protection, and to the point where he was pushed he was pushed to the point where he mentioned the Women's Health Protection Act by name. And And so you heard it straight from the Texas Solicitor General. We need federal legislation or these states are not going to stop. And of course, as sanguine as things seemed with the Texas lawsuits proceeding further, I do think once Dobbs is heard in December, the whole landscape is going to change. And it's not really going to matter, whether or not bounty hunters can enforce abortion bans, because there's going to be a really open season on abortion rights before viability.
And isn't there a state, we're just doing an action alert right now, Barbara, aren't we, on another state that was picking up on the bounty hunting? Ohio.
Yes, Ohio is
copycat.
Doing a copycat law, and we're doing an action alert about that. So I want to do a shout out and say, if all of this is really making you angry, as it should, make sure that you sign up for Freedom from Religion action alerts, because we call on our Freedom from Religion Foundation members to mobilize and stand up for these important issues, or ask the bad issues to not go forward. So that's a really great way to get involved.
Right. So we do have some questions here from Facebook, and so I'm just going to throw some of these out and we can discuss. A lot of these are just like bafflement about the Texas law. So here's one. Can non-Texans be impacted legally by aiding a citizen of Texas in obtaining an abortion? Under SB 8, the answer in general is yes. It's very broadly written and I think one of the doctors who actually performed an abortion in Texas was an out-of-state doctor. But it's very common for out-of-state doctors to fly in and work at clinics in states like Texas, where it is very hard to get a local doctor to perform abortions.
And actually, the two cases that were first filed were by one was in Illinois.
Right.
A man in Illinois who wanted to challenge the law because I think he didn't think it was constitutional. And there was another, I forget if it was Arizona, or they don't even live in Texas. And yeah, they can get involved.
Right,
I mean,
because
this is ridiculous.
What's important about the law, and that this was a source of outrage for many of the justices, not just the liberal justices, was that the law does not require, unlike any other tort lawsuit or you would file a private citizen suit against another party, it doesn't require injury to the person filing the lawsuit.
And yet the people who are injured, the women and the clinics, have no recourse.
Right.
What's wrong with this picture?
It's just completely backwards. So another question, isn't a state law subject to review under the Supremacy Clause, even if not enforceable by government personnel? That was the whole argument before the court on Monday. That was a piece of why the United States was claiming a right to be involved in the suit on Monday, which is defending the supremacy of federal law. So you're definitely on the right track, and we'll see what the court says about this, because truly, as Justice Kagan pointed out with some geniuses, this is relatively novel. Trying to completely evade review of a blatantly unconstitutional law, although there were some analogies brought up in the hearing, such as private covenants, which was a tool for racial discrimination in housing, private contracts between homeowners and sellers and buyers to agree not to sell to black families in order to maintain segregated neighborhoods, even as the laws were changing to outlaw housing discrimination and segregation. And so it's not like the court hasn't faced evasive techniques before, or private discrimination as a tool to maintain the violation of constitutional rights. But this is one of the most explicit, I think, laws that has tried to leave the federal courts completely out of state law.
Speaking as a layperson who's been part of over 90 lawsuits for the Freedom from Religion Foundation, we always have to jump through that hurdle of standing. And the standing has gotten worse and worse.
Right.
And standing means your right to sue, and you have to prove an injury. You have to prove how you're affected by the law. And we have to jump through all kinds of hoops, and often the courthouse door is slammed shut. And here's a law that gives standing to people who've absolutely no business, Badinskis, people butting their nose into
Right.
somebody else's private decision and saying you have the right not only to sue, but to get rewarded for it to the tune of $10,000. I mean, we're like in Alice in Wonderland here.
Right.
Legally.
Per abortion.
Yeah.
These are lawsuits that can be filed for each individual abortion. And so what was brought up at the hearing that is so important is the chilling effect, which is a euphemism in this case because it's an absolute onslaught of litigation you'd be facing as a provider or anyone who in any way aids abortion care in Texas. You're facing each and every lawsuit per abortion with unlimited, there's no preclusive effect. So it's not like if you're sued once, you can't be sued again. And you can't raise any constitutional defenses. That's in the law. So the constitutional question...
Even though what you're doing is constitutional.
Right.
I mean, this is really unbelievable.
Right. Okay, so here's another question. And this is kind of goes to the education goals. So I'm curious what Barbara and Annie Laurie have to say. Is there anything we can do, or what can we do to help more people see or understand that this type of legislation is religiously motivated and not appropriate? Like, what can we do on the education side?
Well, I can say that we have what we call non-tracts. They are defenses against religious tracts. They're little, we sold them for years at cost, and we have one, What Does the Bible Say About Abortion? We have that up on our website. You can find it under publications at ffrf.org. You can see it for free, and it really debunks this idea that the Bible is explicitly anti-abortion. Really doesn't talk about abortion. When it gives an example of somebody who does something that creates a miscarriage, it clearly shows that the miscarried life is not a human life. There's not the same penalties. However, what the Bible is very explicitly misogynist. Women are property. Women are unclean. Childbearing is something that degrades women. So all of that gives sustenance to the Christian right that is very anti-abortion.
Right.
So it's not like it, even though the Bible itself, it's a myth really that it's anti-abortion. It is very, very anti-woman. So
right.
it fuels the anti-abortion movement, but it's really kind of ironic that it isn't. But
right.
But Barbara, do you have a response?
Well, for me, I always think relying on the science, talking about the statistics, that can go a long way, and reminding people that we don't live in a theocracy. We live in a secular country. So you're entitled to feel however you feel about abortion. On a personal level, that's fine. However, those feelings, those religiously held beliefs should not have any bearing in legislation, especially healthcare legislation, that's such a deeply personal issue. So as Liz was saying, these religious comments are brought on the floor. And that has no place in a secular country. We are a secular country. So I always feel when I'm talking with somebody about this, you can feel however you want to feel about abortion on a personal religious level. That's fine. However, that has no place in legislation being created. And then relying on the stats that show abortion is safe. It is effective, that actually women are 14 times more likely to die during childbirth than they are from abortion complications. Abortion is safer than a tonsillectomy.
Or getting your wisdom teeth removed, I think, right?
Yes, it's safe, and it's backed up by medical communities, by the United Nations. The only opponents to abortion are religious organizations, and that's irrelevant when we're talking about legislation in a secular country.
Right. And don't forget, too, when you're having these conversations, most Americans, unlike on some other issues that we deal with, most Americans agree with us. This is not a controversial point of view, what Barbara just said, which is that abortion should be legal and it should be left up to individual choice. That's how the large majority of Americans feel. So when we're talking about these issues, we're really fighting against a rabid and vocal minority viewpoint, which is still very powerful, but also not dominant. So there's one more question here, and I'll just throw it out there. Did yesterday's elections change any of these dynamics? So there were some state level off-year elections, very upsetting for the people of Virginia. And I do think, as we've been talking about, state level legislation is where the ball game is for the people that live in that state. So I worry for the people of Virginia who may now be subject to abortion restrictions in a way that they're not used to having to worry about for the past decade or so. But that's really the consequence of electing conservative candidates who profess to be anti-abortion. I mean, it's very easy to tell where candidates stand on this issue, and it's really important to back candidates who support abortion rights.
And it may also be a consequence of gerrymandering.
Of course.
Well,
And I think also, I just want to add in one point about elections. We often think that the statewide elections or the presidential elections are the most important, but as we're seeing, anti-abortion legislation comes down on a local level in Texas, Nebraska, and Ohio, so local elections matter too, so be involved.
That's right. Well, that's our show for today. It's been almost an hour. Thank you so much, Barbara Alvarez, for joining us.
It was great to be here.
And coming up this week on our broadcast program, Free Thought Matters, Dan and I talk with Manel Salido, the founder of the Humanist Association of Spain. And in this short clip, he describes the time when Spain shook off the repression of religion.
I think that when Franco died in 1975, like people were really a little bit fed up with religion and with all the repression and all that. So people started being more and more free. And then we had, for example, abortion laws in 1995. It was decriminalized. And then you could divorce. I mean, when I was a child, you could not have a divorce in Spain. I mean, it was really another world. It's fantastic how in 40 years, the evolution has been really dramatic in lots of senses, in a very good way.
And you can watch Free Thought Matters on TV stations around the U.S. on Sundays, or you can watch it on FFRF's YouTube or Facebook channels.
And our guest on Free Thought Radio Thursday is Bart Worden. He is head of the American Ethical Union, and you can check out our radio show on ffrf.org radio.
Thank you for watching FFRF's Ask an Atheist. We'll be back again, same time, Wednesday, noon Central, here on Facebook Live.